Hey, Colleen. So what are we doing?
We are reading the script for It Is With Us, and I might be sniffling a little bit.
Who's all here? Are there a bunch of fans here?
So many.
Enjoy, guys, enjoy! You were picked from thousands, and you were picked because of your reasons why.
Don't decide. So even when I read the book, it made me cry. Yeah.
What can we do now to make this the best book to movie adaptation you've
Put
ever
us all
seen?
in a movie.
You are now the only fans in the world who have read the script. So
It translates to a movie really well.
I chose it for me.
So now I think we should make a movie.
Let's make a movie.
Make a movie.
I have an unquenchable thirst for validation, and I farm out my self-worth to external approval in this way that I, honestly, I know shrinks will tell you steer away from that, but it's pretty damn gratifying.
It's been good for you.
It's my version just of a gigantic pile of coke.
Hey besties, it is one of those days where I'm in the middle of filming. I've seriously had 30 minutes of audio recorded and I was ready to hit the submit button and be done editing and upload, and then I got an order from the judge. So we're just going to scrap that whole video and talk about what the judge ruled when it comes to Miss Lively dismissing her claims of emotional distress. There was a bit of a dust up after it was revealed by Wayfair that she was seeking to dismiss her claims and that they were fighting about whether or not they dismissed these claims for intentional infliction of emotional distress and negligent infliction of emotional distress, whether it be with prejudice or without prejudice. And the whole dispute occurred related to Wayfair seeking documentation, wanting to prove these claims. So intentional infliction of emotional distress is a claim that you bring, and you have to have medical records, right, to prove that you have been harmed. And when they were going through the process to compel her to give them documents, a couple days later, apparently she goes to them and says, well, I'm just going to withdraw these claims. And Wayfair said, okay, we can do a stipulated agreement, which means they all agree to the stipulation. It means all parties have to sign off. And it means the dismissal is done without an order from the court. Okay. And Wayfair said that they want her to dismiss them and they're fine with it as long as it's dismissed with prejudice, meaning that she can't refile them. She can't bring them to the court later. And Blake's attorneys then responded with their own letter. And in their letter, they were trying to say, well, this is a moot motion to compel for medical records because we're not going to bring these claims anyway. They know that we're not going to bring these claims anyway. They're only doing this for the media. They're only doing this to try to, showcase to us and you that we're going to withdraw these claims. It's all for it's all for the press. It's all for publicity. It's abusive. They're just doing this to, further harass Miss Lively. And then they asked the court to sanction Lively's attorneys asked the court to sanction Wayfair for filing a frivolous motion to compel for abusing the court docket. And then they also asked them to dismiss her claims without prejudice. Okay. And the disagreement here again is without prejudice and with prejudice. Blake characterizes this difference as a modest change to a stipulated agreement. Well, the judge apparently is not having it with this foolery. And in an order to the court, this is what Judge Lehman ruled. The motion to compel at dockets 261 and 262 is denied based on plaintiff's representation that the relevant claims will be withdrawn. Lively's request that because the parties have agreed to dismiss Miss Lively's 10th and 11th causes of action, the court exercises its inherent authority and authority under Rule 15 to dismiss them without prejudice is denied without prejudice to renewal. The parties shall stipulate to whether the dismissal is with or without prejudice, or Lively shall renew her request by formal motion. For avoidance of any doubt, if the claims are not dismissed, the court will preclude Lively from offering any evidence of emotional distress. So this is an interesting ruling by Judge Lehman because it's on the one hand, it's saying, listen, your motion to compel is ridiculous to Wayfair because she's already said she's going to withdraw it. So it's not really relevant. They're not getting in trouble. They're just saying it's denied because she says she's going to withdraw them. And it's because Lively told the court they've agreed to dismiss the claims. But he then flips it on Lively and tells her that they have actually not agreed. So she went to the court and told them that, listen, we already agreed that they're going to dismiss these claims. We've already agreed to it. And because of that, you need to, Mr. Judge, decide and order the court to dismiss these without prejudice. And the judge is telling her that's not how this works. And he's reminding her that there hasn't been an agreement on the stipulation. And if you recall, if parties agree to a stipulated dismissal, this means in the rules of federal procedure, every single party needs to agree to the stipulations and every single party must sign it. The reason why Wayfair was bringing the motion to compel was they were trying to tell the court that, listen, she says she's not going to bring these forward, but we're concerned that if we do this and stipulate without prejudice, she'll bring them again. And then she'll do it after discovery is closed. And so what the court is telling her is that the two sides need to agree on whether or not it's going to be with or without prejudice. Or else Lively can file a request and file her own motion to dismiss the claims without prejudice, which would then give Wayfair the opportunity to oppose it with or without. So if they say, we want to dismiss these claims without prejudice, then it would give opportunity to Wayfair to say, we don't agree with the without prejudice. We want you to do it with prejudice. Got it? So she has two options. The court is telling her, you either agree on whether it's going to be with or without with Wayfair, or you have to file a motion to which they can then respond to and fight. And that if she does neither, she's going to be barred from bringing any evidence of emotional distress to the court, period. So it's like a warning to her. Like they're not going to mess around. The fact that the judge ruled so quickly and he completely ignored the fact that Lively filed this 4-page letter and told the court that they were being abusive, Wayfair, for even suggesting that she hadn't provided any medical records or provided any names of providers, and that they were being abusive for filing this motion to compel. He didn't even entertain it. He only denied it, not because it was abusive. He didn't strike it from the docket. Instead, he just said it's denied because she says right here that she plans to withdraw them. So they don't really get their hand slapped the way that Blake wants. They're not getting scolded. They're just saying, well, she's telling us that she's going to dismiss these. But I honestly see this as, in many ways, the judge being stern to Lively. Like he's keen to the fact that she's playing a game, right? He is saying to her, you are telling me that you guys agreed to a stipulated motion and you didn't, because Wayfair has told me that you haven't. And then Wayfair told the judge that their concern was that she wants it both ways. She doesn't want to provide discovery. She wants to not be involved in discovery, avoid it, not disclose information or evidence, but then also wants the option to bring the claims back again. And so to mediate that concern by Wayfair, what the judge is telling her is that, listen, if you do nothing at this point forward, if you don't withdraw them, I'm not going to let you even bring evidence to the court, period, that you have any emotional distress. He's at this point barring those claims from being in evidence. So if she just sits there and does nothing and doesn't respond to this, her claims are dead because of the game that she's playing. It's actually pretty stern. And it's telling Blake that you need to work with your opposing counsel. You need to compromise, or else the court isn't going to entertain your claims. And honestly, I would find it rather humiliating to do nothing, but then you know that there's a court ordered on record that says, because of what you did and because of the fact that you didn't agree to a stipulated agreement and because you didn't file your own motion to dismiss and argue why it should be dismissed, I'm just not going to let you bring evidence, period. It's pretty. If you're concerned about Judge Lehman being biased, I would say this is about the most unbiased ruling that a judge could make in this case. He's very clearly not on the side of Blake. And the fact that he isn't even entertaining her idea that they should be sanctioned for this. He's not entertaining that it was improper. He's not entertaining that it was abusive. He's just denying it because she told the court after they filed that she plans to withdraw. Period. So Wayfair in this case did nothing wrong. And in a way, it had to force the court to intervene with Lively. And they said, cooperate with Baldoni and Wayfair, either file a motion or these claims are out, period. And he's not going to allow them regardless. So even if they agree to without prejudice, he's not going to allow them anyway. Again, she can't refile them in this case. It's over. Those claims are dead. This is what I would call fuck around and find out, Blake Lively edition. It's one thing to suggest that someone's being abusive and misusing a docket, and then it's another thing for a judge to tell her, no. So I think the judge in this case is starting to get a little bit weary of her constant filings and the game playing here. And judges in general don't like to have to get in the middle of fights between counsel about things. And it's a responsibility of the two sides to try to work together. So even though they're opposing counsels, right, and they're opposing parties, they still have to get through discovery in a professional manner. They're still expected to come to mutual agreements on different topics. They're not expected to bring every single dispute to the judge. The judge is not there during discovery to play babysitter. And right now, Blake is expecting the judge to be the babysitter and the principal and the disciplinarian. And she's expecting that every single time that Wayfair does something, that it needs to be sanctioned and, uh, penalized. And let me just tell you something. I've been involved in litigation for 3 years in a case, and there's been numerous motions to compel, and we have never once either side been sanctioned. Like, there's been requests for attorney's fees, never awarded. Sanctions are so hard to get. Judges don't like to award sanctions. They don't like to get in the middle of disputes. They expect the counsels to come to agreements. Sanctions are like a last resort. And so, speaking of which, the judge has not yet ruled on the motion for sanctions. So while she gets a bad ruling when it comes to this and she gets a smackdown from the judge, Justin's team filed in opposition to her motions for sanctions. And they basically just outlined why the motion should be denied because she can't use this motion to relitigate and re-argue her motion to dismiss. She's bringing them for an improper purpose. They told the judge that they warned her that this was not the appropriate means to have her claims dismissed. They told her that you can't use Rule 11 to have your case dismissed based on factual arguments or pleading deficiencies, and that they provided her a copy of what the authority of the court is when it comes to Rule 11, and that Blake blatantly disregarded it. And they are actually asking her sanctions to be denied, and they're asking the court to step in and sanction her for bringing forth an improper Rule 11 motion for sanctions against them. And they're asking for attorney's fees to defend against this sanction. Because it's such a technical document, I'm not going to read a lot of it to you. I just wanted to read the very end of it. Lively fails to cite any authority for the notion articulated in her motion that by opposing the motion to dismiss rather than merely amending at the first hint of criticism, the plaintiffs have abrogated that well-entrenched authority that Rule 11 does not apply to the test sufficiency of pleadings, particularly where a motion to dismiss is pending. So her primary argument to the court was that, well, I told Wayfair that their amended complaint has tons of deficiencies, and because of that, they didn't agree to amend the complaint, even though we told them that they either should or not. And the fact that they're waiting for the judge to make a decision on it and whether or not they're going to grant the dismissal with or without prejudice, if they do, that means that I'm right and they're wrong, and they're admitting that they're wrong. it's not a valid argument, it's just kindergarten. And that her request is basically premature, and it's not at all wrong for Wayfair to wait for a ruling on a motion to dismiss to decide what they're going to do and if it's even relevant. Because she could argue all day that and criticize it all day that it's flawed and wrong, but it's up to a judge to decide if it's flawed or wrong and not properly pled. But then using emotional leaven to get around it and re-argue this and get money before is just silly, they're telling the judge. And that seeking sanctions for what the counsel is saying to her about her outside of the court for out of court statements is not at all justified by a Rule 11, and it doesn't cover Rule 11 sanctions. She's using this as a way to tell on them for talking to the press about her and making statements to the press, even though Lively's attorneys continue to make statements to the press about Dustin Baldoni. And they ask them to deny the request for sanctions and that they be reimbursed for having to expend time and resources and money on defending a meritless Rule 11 motion. And they want to deter her from using this again and misusing Rule 11 by making her pay their attorney's fees. And they also want the attorneys in this case to be sanctioned as well, so that the attorneys stop filing all of these motions improperly. And they told the court that they will actually provide documentation of how much money was spent fighting this if it's needed by the court to award fees. I don't know if they will respond with sanctions. It seems like the judge at this point has been reluctant to step in and sanction anyone. It really depends on who the judge is when sanctions come to play. But, at some point, it's sort of a last ditch effort to get people to stop abusing the court. And right now you're hearing the judge warned Wayfair a couple weeks ago by striking their filing. Blake tried to get this motion to compel struck from record. She doesn't want on record that she doesn't want to disclose her medical records. She doesn't want the record to reflect that when she was compelled to reveal discovery about these these claims for emotional distress, that instead of providing it, she decided to withdraw the claims. And she probably doesn't want the court to know that she was trying to have these claims dismissed confidentially so that no one would know. And I don't blame Wayfair for bringing it to the court. I think when you're up against malignant narcissists, it can be exhausting and you have to pick your battles, but this was a battle they were willing to pick. And Blake doesn't want to ever compromise. She wants authorship literally over everything. So I'm just glad to see that the judge in this case he's kind of done with it. And if you notice, he responded to this motion to compel immediately. Think of how fast that was for him. Okay? Think of all the other motions that are just sitting out there that he hasn't touched. They're just out there because he's ignoring them for now. If something comes to the court that he needs to address, he is addressing it. But stuff that's not urgent, pertinent, or relevant, he's ignoring. So a lot of what she has filed thus far has been ignored. And this was just something he couldn't. So Lively is finally scolded by the judge. Finally. I hope this alleviates some of your concerns about whether or not Judge Lehman is biased or not. And I hope you can see now that he is watching what's happening in court and his decision is reflective of that. So Lively has to either compromise with Wayfair, file a motion to dismiss, which would give Wayfair the opportunity to argue that it should be with prejudice. And if she does neither, the judge is done. She's not allowed to bring these claims, period. She doesn't get to provide any evidence of emotional distress, period, for any claims. No evidence for emotional distress. Her attorneys were trying to claim that she was getting rid of these because other claims that she has include emotional distress. The judge is saying, if you don't get rid of these, you don't get to do any offering of any evidence, period, of emotional distress. And this is going to be really hard for her to prove her case. How do you prove that you should be awarded damages for what happened to you if you can't prove to a court that what occurred to you was so egregious that you should be awarded damages. Cases of sexual harassment have to be severe and pervasive, and that's why most always they include claims with hand in hand of intentional infliction of emotional distress. So how does she then prove that this was severe and pervasive if there was no lasting impact to her? She can't. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye guys.